Good. First of all, thank you all so very, very much for being here. Thanks to those of you who are live, and thanks so much also to our virtual audience. I am Lolita Buckner-Innes, for those of you who don't know me, and I am the Dean of the University of Colorado Law School. It is my very, very great pleasure to welcome Verna Williams, CEO of Equal Justice Works and former Dean of the University of Cincinnati College of Law, and she will serve tonight as our 65th annual John R. Coen Lecturer. The Coen Lectureship was established in memory of John Coen, a member of the Colorado Bar, and someone who very much valued the importance of public dialogue and discussion. This lecture was established in order to make sure that we at Colorado Law had the opportunity to hear topics of interest that were in the public benefit. We are therefore delighted to have Dean Williams, as I call her, because I will never stop calling her that, even though she's no longer the dean at Cincinnati. We are delighted to have her, for in her role as CEO, Dean Williams advances the mission to create equal opportunities for leaders to transform their passion for equal justice into a lifelong commitment to public service. This is more especially an honor for me to host Dean Williams, because as we were chatting upstairs earlier, I think I recall that you are among the very first law professors I met when I was very junior in this profession, and so it's a delight to be here. We also chatted a little bit about the people that we know in common, and for those of you who know me, I'm always talking about degrees of separation, and it turns out that we are but 1 degree of separation, and maybe a half degree of separation from Michelle Obama, because one of the first employees I had was also the roommate of Michelle Obama, and I also tutored the roommates of Michelle Obama, who was a lot quieter in those days when I used to see her sitting in the corner. And Dean Williams is a pretty good friend of Mrs. Obama, and so I love thinking about how close I am to famous people, including Dean Williams. Dean Williams has had a distinguished career as an academic leader, as a law professor, and before that, as a renowned lawyer. Before joining the Academy, she was Vice President and Director of Educational Opportunities at the National Women's Law Center, where she focused on gender and equity in education. Her work as lead counsel was vital in the 1999 U.S. Supreme Court case, Davis v. Monroe County Board of Education, where she led the petitioner to victory and helped resolve the question of whether a school board could be held liable, or responsible, I should say, under Title IX of the Education Amendments of 1972 for student-on-student harassment. Some of you may recall that case where Dean Williams represented a parent acting as next friend to her daughter who experienced ongoing sexual harassment by an elementary school classmate. This case established the notion that educational institutions have a duty to respond to and address complaints of student-to-student sexual harassment. Dean Williams is a cum laude graduate of Harvard Law School and of Georgetown University. Now tonight, the title of Dean Williams' talk is, Let's Talk About Race. And I think more than ever, that is an important topic, because as she and I were chatting, notwithstanding the fact that we are now in the new millennium and we have been for a couple of decades, that still is one of the most difficult topics to talk about in our society. Dean Williams will examine current attacks on and efforts to limit diversity, equity, and inclusion programs, especially given the U.S. Supreme Court's recent jurisprudence. So, without further ado, I want to invite Dean Williams up to the podium. However, before I do that, I have one last task. I want to give a land acknowledgement. As we gather, we honor and acknowledge that the University of Colorado Law School is on the traditional territories and ancestral homelands of the Arapaho, the Cheyenne, and the Ute peoples. Further, we acknowledge the 48 contemporary tribal nations historically tied to the lands that comprise what is now the state of Colorado and what is now the University of Colorado, Boulder. And now, without further ado, Verna Williams, please come forward.
Thank you so much, Dean Innes, for that generous introduction. Now, it's true, I am friends with Michelle Obama, but I have to say, I can't boast a photo with Deion Sanders. So I'm looking at you, Dean Innes. I was hoping that maybe you would invite him to today's talk, but maybe he's watching virtually. Yeah, so if so, go Buffaloes. Okay, so thank you so much. I am so happy to be here. I'm so happy to be here now. COVID prevented me from coming in April. I'm so happy to be free of COVID and here with you today. That said, following in the footsteps of Deborah Archer, Akil Reed Amar, and Jeffrey Stone, who also delivered this lecture, is humbling and a little bit intimidating, especially now that I am miles and years away from engaging in scholarly pursuits full time. As Dean Innes explained, a little over a year ago, I left the academy to return to the public interest world. Although I no longer teach or write in the areas of critical race feminism, what I learned as a scholar continues to inform my work. As many of you know, Equal Justice Works, which I have the great privilege of leading, is the nation's largest facilitator of public interest fellowships. When my former students found out where I was going, they looked at me with a whole new level of respect, as in, now that's a good job. In the past 37 years, Equal Justice Works Fellows have worked in communities in 45 states. We have over 2,500 alums, 85% of whom continue working in public interest law after completing their 2-year fellowships. And I know that 100% of our community is committed to the ideal of equal justice for all. The impact of Equal Justice Works is and has been enormous, from the many fellows we launch and the host organizations whose capacity we've helped expand, to the robust pro bono networks corporate and law firm partners leverage. Equal Justice Works is and has been about access to justice. In this moment, when rights we thought were well settled are in jeopardy, Equal Justice Works also has a role to play in addressing one of the primary barriers to justice, race and racism. In the time that remains, I plan to do what many in this nation would prefer that I avoid doing. That is, talk about race, affirmative action, and how we need to keep going, even as the forces of fear seek to turn back the clock. To be honest, there is a part of me that doesn't understand why race is such a taboo topic. And maybe that's the professor in me, the critical race feminist scholar who spent hours reading, writing, thinking about race and gender too. Just last week, I was discussing the racial and gender dynamics of Love is Blind Brazil with my daughter. I know that's not how most people operate, and I didn't always operate that way either. When I was 10, my family moved from Southwest Washington, D.C. to Oxon Hill, Maryland, or the country, as I called it. I left a predominantly Black school and neighborhood for a school and neighborhood where I was in the minority, where my skin tone was a barometer for how well my classmates had tanned, where my hair was a source of fascination, and where I was either not like other Black people or I had no race at all, the ultimate compliment. I made friends, to be sure, my little basket of nuts, that's what my mom called us. We were honor students, all of us. But I alone was not selected for the Talented and Gifted program. I was the very last one to be recognized by the local Rotary Club for my academic achievements, and the only one told not to get my heart set on attending the college of my choice, Georgetown University. Each of these occurrences generated some degree of confusion, anxiety, and hurt, but never once did I think that race played a role, even though race was the one thing setting me apart from my friends. It never entered my mind. By the time I enrolled in law school, however, my racial and gender identity were in formation. As a 2L, I reached what I now recognize as a turning point. Still standing, if a bit shaken by a bruising and confounding first year, I enrolled in Professor Randall Kennedy's Race, Racism, and American Law course. It introduced me to history never broached in high school or college. For example, I learned about Black codes, the laws states passed after the Civil War to preserve their shacklehold on Blacks. Some authorized arrest of unemployed Blacks as, quote, vagrants. Others allowed employers to remove children from their parents to apprentice them. I learned about the nation's nadir in race relations, the turn of the 20th century, when lynchings were community events that families attended. Members walked away with a souvenir, ear, toe, or other body part. Participants even shared the spectacle by sending postcards to people who couldn't attend. Each course assignment was revelatory, something I gobbled hungrily, even as I seethed with rage. Why hadn't I learned this history before? The materials and discussion in Professor Kennedy's class demonstrated in graphic terms sometimes how deeply race and racism are in our system. In that class, I learned how to use legal analysis to unmask racism and advocate for change. I better understood the plight of Black people in the US, and I felt equipped to analyze present-day practices for their racial impact. By the end of Race, Racism, and American Law, I felt empowered, and that maybe I belonged at Harvard Law School after all, that maybe I was there for a reason. Professor Kennedy's course planted a seed in me, a hunger to attack racism's deep tentacles in society. In every position I took after graduation, I sought opportunities to make a difference. And so when I think about the impact of that one course on me, I can understand why such knowledge would be deemed problematic for some people today. W.E.B. Du Bois said long ago that race was the problem of the 20th century. If he were here right now, he'd certainly amend that statement to include this period we're in, this post-Obama, post-George Floyd, post-global Black Lives Matter period, when people around the world from Finland to South Africa called for social justice. The nation that was 80% white when I was in law school is now 60% white. That demographic change has heralded extraordinary highs and lows in racial history in less than 20 years. We're in the midst of great transformation, which, though exciting to me, clearly is terrifying to others. Consider the movement against critical race theory, or so-called wokeness, and more recently, the Supreme Court's affirmative action decisions. When I prepared to speak with you all in April, the airwaves were saturated with attacks on critical race theory, with right-wing extremists saying critical race theory was responsible for riots, low test scores, and even, according to the Heritage Foundation, the murder of 17 teenagers at Marjorie Stoneman Douglas High School in Broward County, Florida. Education Week reports that 18 states have banned or restricted teaching critical race theory or limit how teachers can discuss race and gender since January 21. According to the Washington Post, 160 teachers have lost or been forced out of their jobs since 2020 for teaching or expressing opinions about racial or LGBTQ issues. PEN America, which fights for free expression, reports that from July 21 to December 22, schools banned 1,477 individual books dealing primarily with themes of race or LGBTQ+ issues. PEN America and Random House have partnered with authors and parents to challenge one such ban in Escambia County, Florida. The complaint alleges that the school board restricted access to certain books based on their content, violating the First Amendment, among other things. For example, school officials removed Race and Policing in Modern America for allegedly pushing the idea that all police are bad and non-blacks are racist. They also banned When Wilma Rudolph Played Basketball, a picture book about the late Olympic track star and her upbringing in the segregated South for demonstrating race prejudice, according to the complaint. The complaint notes that the push for banning books is national in scope, which won't surprise you. It's led by such organizations as Moms for Liberty, formed in 2021 by two Florida women, Tiffany and Tina, according to their website. Moms for Liberty claims to be on a mission to stoke the fires of liberty. In that vein, Moms for Liberty is dedicated to fighting for the survival of America, they say, by unifying, educating, and empowering parents to defend their parental rights at all levels of government. One of its strategies is, quote, sharing and disseminating lists of books it finds politically objectionable and urging individuals to seek removal of those books from school libraries. The Tennessee chapter's activity is illustrative. Moms for Liberty complained to the Tennessee Board of Education about several books, including Ruby Bridges Goes to School, My True Story, written by Ms. Bridges, who at 6 years old integrated a New Orleans elementary school. This book for first and second graders was deemed problematic because of its, quote, harsh and dark depiction of a large crowd of angry white people who didn't want black children in a white school. Moreover, the book didn't offer redemption at the end of the story, according to Moms for Liberty. According to the complaint, Bridges' book only highlighted race and created further division among the new generation. We want our children to be colorblind and value people for who they are and not for the color of their skin or past evils or mistakes committed by other people in society, in history. Moms for Liberty says that it seeks to promote liberty and embrace the founding principles of the nation to protect America and her children. As a mother and a former constitutional law professor, I understand and embrace those values. But for the life of me, I can't understand why one mother's distaste justifies preventing my child from reading that book. In other words, what about the other parents who want their children to learn an unvarnished version of history? Is their liberty unimportant? And as the mother of a black girl, I also understand the urge to shield kids where appropriate. But when I examined Ruby Bridges' book, here's what I saw. 5-year-old Ruby, dressed up for the first day of school. Her hair is neatly pressed and it's braided. Her skirt and sweater ensemble are set off by every little girl's dream footwear, patent leather Mary Janes. But even as Ruby totes a leather book bag with her right arm, she is gripping her mom with her left arm with all the strength that she can muster. Surrounding her, not other kindergartners, welcoming her to their school or teachers with a ready hug. No, white adults swarm her, holding signs saying whites only, pickaninny, or simply emblazoned with that symbol of Southern culture, the stars and bars. To be sure, some grown-ups lack signs. They're raising their fists and have contorted their faces as they scream at 5-year-old Ruby. This kindergartner who was merely exercising her constitutional right with a mom trying to protect her. The pictures are unsettling, but they depict a messy truth about our nation, our imperfect truth that, contrary to the Tennessee Moms for Liberty complaint, that story does contain some elements of redemption. Rather than tell the whole story, though, the Moms for Liberty would skip the hard parts and get to the happy ending, the so-called colorblind nation. And that's the goal, according to Moms for Liberty. And they're not alone. The U.S. Supreme Court, in service of this colorblind ideal, struck down the affirmative action programs at Harvard and the University of North Carolina, holding that they violated the Equal Protection Clause of the 14th Amendment. Race is so inflammatory a category, according to the court, that the state may not use it even to remedy past discrimination, except for the most limited circumstances. Attempting to anchor its ruling in history, the majority opinion dutifully marches through the unfortunate mistakes the court has made in the past, such as the Dred Scott decision and Plessy versus Ferguson, building to Brown versus Board of Education's redemptive arc. The court manages to read even that soaring decision as supporting limited consideration of race in higher education, which became even more constrained thanks to the court's rulings in Bakke, Grutter, Fisher, and now Students for Fair Admissions. In the majority's U.S., race-based remedies have become less necessary over time. Indeed, Grutter forecasts that they would be phased out in a matter of decades, according to the majority. Picking up the baton where the court dropped it, right-wing extremists now seek to eliminate diversity, equity, and inclusion in other areas on the grounds that Students for Fair Admission outlaws them. For example, attorneys general from 13 states have threatened to sue Fortune 100 CEOs for their DEI efforts. Arkansas Senator Tom Cotton piled on, advising top law firm managing partners to preserve their documents in anticipation of investigations and litigation if they dared continue diversity initiatives. Finally, the attorney representing the plaintiffs and Students for Fair Admissions is turning his attention to the Fearless Fund, which is dedicated to supporting Black women entrepreneurs. Just last week, Students for Fair Admissions filed suit against West Point. Make no mistake, by targeting Harvard and UNC, that was the first salvo and yet another skirmish in the culture war, coming from a very well-resourced conservative movement. Even the most cursory of searches uncovers donations that boggle the mind. For example, the Marble Freedom Trust, whose proclaimed mission is to maintain and expand human freedom, launched in 2020 with a $1.6 billion gift from one benefactor. But for all the outrage about division supposedly caused by teaching the truth about our history, these advocates for parental rights and liberty have adopted anti-democratic, unconstitutional methods in their attempt to create a whitewashed national narrative. Guided, no doubt, by focus groups, they seek to fan the flames of fear, to stoke discord in their quest to preserve a status the majority of us has rejected. According to the Pew Charitable Trusts, most workers support DEI efforts at work, for example. In dissent, Justice Jackson advises us how to respond because we must be, well, what do we do? We've got a minority moving ahead and pushing a particular agenda. Justice Jackson's dissent says the only way out of this morass for all of us is to stare at racial disparity unblinkingly and then do what evidence and experts tell us is required to level the playing field and march forward together, collectively striving to achieve true equality for all Americans. So what does it mean to confront racial disparity unblinkingly? Well, I'd start with understanding how we got here. Perusing Justice Jackson's opinion, for example, which articulates clearly and robustly the history surrounding ratification and implementation of the 14th Amendment. In discussing the second founding, Justice Jackson explains that Congress was responding to state tyranny against the newly freed Black citizens. Just as in 1789, these framers developed provisions to combat state oppression, amending the Constitution and authorizing Congress to take the necessary steps to make the promises a reality. To that end, Congress passed measures specifically to assist Black people, such as the Freedmen's Act and the Civil Rights Act of 1866, recognizing that 2 centuries of race-based subjugation could not be overcome by a racially neutral legal regime. Justice Jackson also charts the many ways state, local, and federal law, time and time again, failed to live up to the promise of the Reconstruction Amendments. From excluding Black people from the Homestead Act and enacting zoning regulations to limit Black progress during the Great Migration, to discriminatory lending policies of the federal government, Justice Jackson observes that government policies, this is my favorite part, government policies affirmatively operated, one could say affirmatively acted, to dole out preferences to those who, if nothing else, were not Black. So we had affirmative action. It just wasn't for Black folks. And that's not even considering the GI Bill, which gave $95 billion to veterans and was deliberately designed to accommodate Jim Crow by allowing states to administer programs instead of the federal government. That move alone enabled the well-established discriminatory practices that were occurring before the Second World War to continue, but with the added insult that federal funds would be made available to ensure white access to home ownership, white access to college education, and other tools that created our middle class. Then she connects the past to the present in a key move, noting that the myriad preferences white people have received throughout our history have compounding effects, resulting in wealth, education, and health gaps that flow inexorably from centuries of disparate treatment. For example, in 2019, Black families' median wealth was approximately $24,000. For white families, that number was approximately 8 times as much, about $188,000. In education, Black Americans in their late 20s are half as likely as their white counterparts to have other college degrees. Additionally, because of wealth disparities, Black college graduates have twice as much debt as their white counterparts. Health disparities, she notes, are the predictable result of opportunity disparities. They lead to at least 50,000 excess deaths a year for Black Americans vis-a-vis white Americans. That is 80 million excess years of life lost just from 1999 through 2020. Meanwhile, tying wealth and health together, Justice Jackson says the typical Black American, while she lays dying, pays more for medical care and incurs more medical debt. Justices Jackson and Sotomayor make plain that this nation never has been colorblind. Indeed, states, localities, and the federal government created an intricate, racialized web that reserved opportunities and access to white people. The disparities created early on have resulted in compounded and expanding gaps affecting all aspects of life. In a very real sense, state-sponsored and state-sanctioned discrimination have impeded upon life, liberty, and the pursuit of happiness for far too many, for far too long. And that is what an unblinking look at racial disparity tells us. So now what? Well, then we turn to the second part of Justice Jackson's prescription, leveling the playing field. And that is a question for all of us. Here's what we're thinking at Equal Justice Works. The Legal Services Corporation reports that 92% of low-income people's legal needs go unmet in this country, 92%. When we factor in people living above the federally mandated limits for legal aid, that is, those folks living at or above 200% of the poverty line, the need expands exponentially because they can't afford their own lawyers and they don't qualify for legal aid. This situation is simply untenable. Specifically, in far too many cases dealing with child custody, bankruptcy, domestic violence, discrimination. In other words, cases where outcomes have meaningful consequences, people lack representation. At Equal Justice Works, our primary strategy for addressing this massive problem has been funding and placing fellows in public interest jobs. When I joined the organization, I wondered how race fit into our work. And that's a question I think all of us can ask. How does race fit in? I consider our housing justice program. Equal Justice Works launched this program because evictions have a disproportionate effect on communities of color, women and children. Without access to safe and stable housing, individuals and families can face a variety of negative outcomes, including long-lasting and devastating economic hardships and health problems. This program operates in areas where evictions and housing instability have reached epidemic proportions. During a 2-year term, fellows who include lawyers as well as community organizers work collaboratively to provide legal advice, referrals, and full representation for tenants in eviction proceedings. They also engage in education and outreach activities, and they work with community partners to address systemic barriers that contribute to housing instability. Now, this program started out in Richmond, Virginia, a city with an eviction rate that is the second highest in the nation, next to Charleston, South Carolina. I'm so pleased that thanks to funding, we've expanded this program to include Charleston and Columbia, South Carolina, as well as Charlottesville and Fairfax, Virginia, and Baltimore and Easton, Maryland. These are all areas that the Eviction Lab has identified as having some of the highest eviction rates in the country. And this program is just one example of how our fellows are confronting racial inequality and working to level the playing field. In addition, my colleagues and I seek to integrate our values of diversity, equity, and inclusion throughout our work. In that regard, we plan to develop a racial justice program. We've embarked on anti-racism training at the organization and will provide such training for our fellows. We also are exploring developing a pipeline program that would bring more people of color into the legal profession, a profession that is 80% white and it hasn't moved very much over the last 10 years in terms of those demographics. We'd also like to create a fellowship program for legal assistants, law techs, community organizers, in other words, non-lawyers who can provide much-needed legal assistance. And finally, we seek to develop our own research and data analytics capacity to help make the case for why representation matters in every sense of the word. With this strategic vision, Equal Justice Works seeks to rise to the new challenges presented by this critical moment. It's a vision we crafted with many of our partners, public interest organizations, law firms, law schools, corporations, individuals, and law students. Law students is how we got started in 1986. Then as now, we collectively are committed to making the words above the U.S. Supreme Court's door a reality. Equal justice for all. For me, it's a commitment to getting into what the late John Lewis called good and necessary trouble, which is just what we need now. With the court's reversal of critical precedents, the resurgence of hate in corners both small and large, and the sheer magnitude of challenges ahead, the prospect of engaging in the struggle may seem intimidating, may make being quiet seem the path of least resistance, especially where race is concerned. But here too, the dissenters in Students for Fair Admissions can provide a balm and some guidance. When I read that history from Justices Jackson and Sotomayor, I'm reminded that we have been here before. We have been here before. The going always has been tough for those fighting for justice. But to paraphrase the magnificent Sherilyn Ifill, former director counsel of the NAACP Legal Defense Fund, at no point in our history did we utter, "We give up." We do not give up. We will keep going. We will keep moving forward. That's what drives me and my equal justice colleagues. I invite you to join us in marching forward, following Justice Jackson's charge to stare unblinkingly at racial disparity so that we can achieve equality for all Americans. Thank you so much, and go Buffaloes. Okay, I am happy to take any questions or comments, or we can just go to the reception. It's all up to you. Professor Norton. I'm so pleased Professor Norton is in the audience. I have to say that she and I go way back, way back to the trenches in Washington, D.C. Well, she was at the National Partnership for Women and Families, and I was at the National Women's Law Center. I have lots of great memories of working with Professor Norton.
Right back at you, Dean Williams. We're not old friends, we're long-standing friends.
Thank you. I stand corrected. I stand corrected, sis. Yes.
So I'm guessing that a lot of students, either here in the courtroom or watching online, are inspired not to give up, right?
Good.
And just inspired to support you in this important work. And I wonder if you could reflect a little bit on the things that you did when you were in law school that helped prepare you for this work, the sorts of skills or experiences that you acquired, or reflecting on the skills and experiences that you wish you had acquired and that you see young lawyers succeeding in this effort, the sorts of behaviors they should undertake now.
Yeah, wow, great question. Well, the first thing, like I said, I took Professor Kennedy's racism course. I mean, if there are courses that are talking about race and law, gender and law, that they're going to open your eyes in lots of different ways. For me, I talked a lot about how the subject matter really resonated, in part because I didn't know anything about that history. But the other thing, there's something about that subject matter and the legal framework. Like, I finally got it. In other words, I was like, oh, we take the cases and we apply them to these situations. There was something about opening the door because I was taking a course that was really intrinsically interesting to me and resonated with me. So I invite you to take those courses. I know sometimes people may feel like, oh, I can't have that on my resume because if I do, a law firm won't hire me or it will limit my options. And I that's your choice to make. But I also will say that if what you want to do is work in this area, then it's best to just present yourself as you really are. Just go ahead and be you, as they say, you do you. Be your authentic self. Don't feel like you have to hide it. There's nothing to be ashamed of. Take those courses. Work with folks that are, in a lot affinity groups. I got fed a lot through the Black Law Students Association. It was great meeting other Black students going through the same thing. Many of them were like mentors, the students that were a couple of years ahead of me. And I later became the president of the Black Law Students Association and worked with the administration to try to get some changes. It's so funny now, looking back on my experience as the BALSA president and meeting with the dean and I even met with the president of Harvard University. Those were experiences that actually helped me prepare for advocacy when we were working in Washington. I was not a stranger to sitting down with a person in authority and talking about, okay, now this is the issue. And these are the things that we think you should do to help fix the problem. And that's the other thing, is to be to remember that you're problem solvers. It's all well and good to think, to identify the issues and to learn about the problems in our society. Now is the time to also start thinking about how do we solve them? How do we solve them? Because that's our way out. So those are just some things at the top of my head. Oh. Professor Malveaux.
Thank you.
We don't go back as far.
No. I'm younger.
Wow.
No.
Wow.
No.
Who's next? Who's next? Did I see another hand? Okay.
Share the mic. I'm amused by the 1 degree that you guys mentioned earlier, because I didn't know about your connection with Michelle, and she actually was one of my law school advisors when I was in undergrad to advise me when I was applying for law school. So that 1 degree is real, right?
Yeah.
So anyway, I so appreciate your comments, and I was hoping you might talk a little bit about the affirmative action cases a little bit more. One of the things I'm sure, is there were a group of us Black women scholars who did an amicus brief that Sotomayor had mentioned in her dissent, and we made this argument that many others made about a colorblind constitution. And, Justice Jackson in her dissent also talked about that, and it's very, there's this real debate. We argued it was not colorblind, and of course there were other folks, the majority took the position that it was, and it's very frustrating because you're looking at the same history around the 13th Amendment and the 14th Amendment and all the Reconstruction civil rights statutes that came from those. And everybody's looking at the same history. The majority is acknowledging that history, and yet having a very different interpretation of it and using it in a very different way. And I was sort of shocked to see there was a quote that Chief Justice Roberts had in the majority where he quoted Robert Carter, who I had clerked for, and he argued Judge Carter had argued the Brown decision with Thurgood Marshall, and he took Robert Carter's language and weaponized it because he was arguing for the equal rights of Black children in the Brown decision, and yet the language was made to seem as if he was arguing for a colorblind system, right, against racial remedies. So I was hoping you could talk about what do we do with that? I mean, I don't know what to do because we're in a society which often doesn't appreciate facts, and when we do agree on the facts, we actually interpret them very differently.
Yeah.
So where do you go from there if you have the majority opinion as adopting a version of history and sort of distorting and weaponizing it?
Yeah, I don't know. I mean, they're always quoting Justice Harlan in Plessy, and every time I read Justice Harlan in Plessy, I think he's not exactly a progressive. It's true. He says the Constitution is colorblind, and there's nothing in the Constitution that requires the state to do what it's doing. He also says that the white race is superior, and it will always be superior. And so that's another reason why the state doesn't have to do what it's doing. And moreover, he talks about there's a race that's so different from our own. The Chinaman is what he says. That's his quote. So I feel like I personally, I wouldn't really be quoting Justice Harlan about colorblind and trying to lift that up and, wow, what a visionary he was. I mean, he's right on the one hand, I suppose, like literally speaking, but really implicit in his argument is we don't really need to do this stuff because we already know who rules supreme. It is the white man. And we mean white man, right? So what do we do about that? I think we have to go on. We can continue talking about it. We can continue, because I think if we can learn anything from the right, it doesn't matter. If you lose, you just keep going and you keep pressing your point until you're successful. You think about, let's say, we've used the techniques of originalism, the so-called techniques of originalism, but as well as I do, Professor Malvo, that that's something that's made up. There's no real method. Supreme Court justices are not historians. And at one point, this was laughable. It was actually laughable. But what they did in a very well-financed move, getting the professors and getting the research that they want to continue pushing it forward until now, all of a sudden, it's a method. So we got to figure out what's our method. What's our program? What's the story we want to tell? And I think that's, instead of, saying, why won't they listen? Well, let's talk about the Constitution the way we know, the story we know, And the narrative, we know, because there's no way in hell that Robert Carter wanted a colorblind world. There's nothing colorblind. I mean, I'm starting to sputter. There's nothing colorblind about the Constitution. From the 3/5 clause, the 1808 supposed termination of the importation of slavery, the myriad compromises that were made to accommodate slavery. This is a very color conscious or slavery conscious Constitution. But this is why they want us to shut up. And the thing we have to do is to just keep talking. Just keep talking and keep telling that story. I think we could say it is emblematic of the success of our movement, that we have been able to move them to the point where they just want to shut it down. Because even also, Justice Roberts Chief Justice Roberts writing for the majority saying, I don't know why Justice Jackson is talking about all this societal discrimination, because we already decided that is not a good reason. That does not satisfy strict scrutiny. First of all, I was just kind of like, get the word stare decisis out of your mouth, because you don't care about stare decisis. Right? And then secondly, it is too late in the day to suggest that when we talk about societal discrimination, that we're talking about it like we did in the 70s. There's been too much work done that links what happened in the past to the conditions of the present. And Justice Jackson does that work beautifully. So we just have to keep going. We just have to keep going. And it's gonna be a long road to hoe. But let's keep going. We keep talking about it, keep telling that story. We can't give up. They don't give up, and neither do we.
Hi, Verna, thank you so much. That was so wonderful, and you state so many of the things that I know inside my head are true, and I'm like, it's okay. We're going to keep going. So I'm a lawyer, so I have a forward-thinking strategic question. So as you say, which is factually true, they're coming after more programs. They're looking to target schools that are still, in their opinion, using race-based preferences, and I think they're coming after, it's a matter of time if they're not already, coming over race-based scholarships. So specifically, money that is set aside to diversify campuses. And so I'm thinking specifically where in the area where I work, I spend a lot of time on main campus supporting our undocumented students that go to CU Boulder, and none of them are eligible for federal financial aid. So we do specific fundraising because of that absence of financial support that all of the other students are typically eligible for. So we're starting to have conversations about whether or not we can continue to fundraise in that manner, whether we can specifically state that donors would be supporting undocumented students who lack immigration status, almost all of whom are students of color. And the conversation is, veering into that space of being risk averse, and maybe we take the word undocumented out, and maybe we just say that it's eligible for students who don't have access to federal financial aid, and we just don't say why. And so I'm wondering strategically if I do want to look unflinchingly and unblinkingly back and think about ways to do it. And I'm thinking, do we, as a strategic matter, in the end, the goal is to continue raising money for these students. So do we acquiesce in some way by sanitizing the language so we can get there? Or should we stand unflinchingly next to it and be proud of the fact that we're fundraising for undocumented students and not shy away from those words? I don't know if you have any thoughts about specific things like that as we move forward.
Yeah, first thing is, this is not legal advice.
Not my lawyer.
This is not legal advice. I've been out of the trenches for a long time. I'm taking the court literally. They say race, right? Race. Undocumented status is not race. It's not. And nor do you have the intent of focus. I mean, they can get into the intent, all they like. But to me, I'm not seeing race there. I mean, any more than I would see, I think about For Equal Justice Works, for example, when I'm thinking about this pre-law fellowship, I'd like to target students attending HBCUs and predominantly Hispanic serving institutions and institutions that are serving Native students. I mean, that's not race, that's institutions. I think we have to be thinking like that. And I think you're right. I think your instinct to like go, look, just hold on. They're not saying everything is done, and they haven't yet said, I mean, this is a court that knows how to say, we overrule X. We've seen them do it. They have not overruled Grutter, notwithstanding what Justice Thomas says. They haven't, not yet. So, and why would we give that to them? That's how I think about it too. Why would we give that to them? Why are we gonna roll over? We're not rolling over. We're not giving up. That's what I would say. I mean, and I know, have I had those tough conversations yet with donors? No. So far, we seem to be, okay. They want us to be, and we will be careful. But when I think about even like the racial justice program that I suggested we'd like to create, that is something it would be a program that's focusing on addressing racial injustice. Anybody can do that. I mean, certainly the court is not saying I can't even think about addressing racial justice. Really, are we going to go that far? We can't even think about race? Seriously? So I would encourage, with again the provisos, not legal advice. I would encourage, like, let's look at the opinion. Let's look at exactly what it says, and remember, look at Dobbs. This is not Dobbs, not yet anyway. And the fact that it's not yet, then let's take advantage of the not yet. I think Tim has a question.
Hi. The affirmative action decision made an exception for military institutions.
Yes.
And which is being challenged.
Yes.
But can you explain or shed some light on the rationale for mentioning that in light of the decision that they were actually making?
I have no idea.
And where that comes from and how they can justify it? Does it just come out of the blue? They just say it. So
yeah, I mean the only thing I can think of based on what the court used to do in the past is to say, well, that question's not before us right now, so we're not addressing that question. We're just looking at UNC and at Harvard, and we'll deal with the military academies later, which they will because a lawsuit is happening. So it'll be interesting to see what happens. I mean, certainly when Grutter was being litigated, there was a plethora of briefs that were submitted, many from the military, talking about the value of affirmative action in the context of the military and the value of a diverse military. That they learned in Vietnam, for example, how important it was to have diversity, that it was important for national security. So I don't know if they're, making way for that national security might be the sort of compelling governmental interest that might justify consideration of race. We'll have to see. But no, I have no idea, Tim, why they did what they did, why they even brought it up.
Hi, thank you so much. This was really inspiring. I really appreciate hearing your perspective. And listening to your answer to these questions, I think I might know how you're feeling about this, but I want to just hear your perspective about the role that the law plays in this debate. We're going to keep going. The other side's not stopping. We're going to not stop. It sounds a little bit like we're going forward in resistance. There's other parts of your answers that make it suggest that this isn't really a resistance movement. We do think that the actions that we're going to take going forward are congruent with the Students for Fair Admissions decision, or at least the nuances that are left over. And you began by saying, we're going to push until we find success. And what I see is, okay, if you find success and you get a Supreme Court opinion that goes the other way, the other side's going to make the same speech that you made.
Yeah.
We're going to keep going because they didn't stop, and we can find holes in the majority opinion, and we'll keep going. And so then it makes me wonder, is the law or the Supreme Court, is this the battle that will resolve this issue, or are we barking up the wrong tree?
That's a good question. I don't know. I mean, you can certainly look over the decades and see there's certainly been movement. I mean, I used to always think of the trajectory of civil rights law or women's rights law as like a sine curve, right? You have highs and we have lows, and we have highs and we have lows, or it's expanding and contracting, and we are now in the contraction stage. So what else is there? As long as we have the court that decides what the law means, I don't have an answer for you, Doug. I mean, I think we have to do deal with what we have. I guess we have to think about it shines a greater light on the need to look really nationally, and by that I mean like I'm thinking about the Moms for Liberty as an example. We have focused a lot of our attention on the national politics, the United States Supreme Court, but we've lost ground when it comes to school board elections, city councils, things of that nature. I think these are all signs that we need to really re-engage in our communities and speak up, and particularly if we feel like, and I think we're right to feel this way, this what's happening now is not what the majority of people want. So the majority, we need to get up and speak our truth, what it is we want. And maybe that's not so dependent upon a particular composition of the United States Supreme Court. But I'd have to give more thought to that answer. I think you're right. I guess at the heart of your question, at least what I'm hearing at the heart of your question is, what's the other part of the strategy? What else should we be doing? And I think we need to sort of step back. I think it's like everything, right? Everything. We got to get involved in our, city council and neighborhood council and the school board. And you have to think about, like, are there ways, letters to the editor? And then we have to think about, like, the media, what's available there. All these things that have been, they've silently been pulled back from us. And now we have these big voices. Kind of a monopoly about some of these things. It takes other minds than mine to talk about how to combat that. But I think your suggestion, Doug, is that it's a multifaceted, multi-year, multi-angled strategy is right. Yeah.
Our last question for the evening.
No pressure.
I want to thank you for this evening. It's been really educational. I appreciate you. My name is Hopeton Willis, and I wanted to hear your opinions or comments regarding our society being part of a caste system. Just finished reading Caste by Isabel Wilkinson.
Yeah.
Wilkinson, and I found it eye-opening, and wanted to hear what you had to say.
First of all, my hat's off to you, brother, for reading that book. I started reading that during the Trump administration, and I could not. I was so angry. I was so angry. I tend to read at night, and so I could not get to sleep at night reading that book. So I have to pick it up. I also understand that Ava DuVernay made a movie. Yeah, she's managed to turn that into a film, so I'm looking forward to that. I think Wilkerson is right. We do have a caste society, and it is quite. I mean, we can look. This is again one of the great, I think, aspirations, I'll say, of this nation is that you can be born in a particular class and you can become the president of the United States. Look at Barack Obama, right? But I think in truth, I mean, it's very difficult to get out of the class that you come from. I feel very strongly that, in fact, I feel like I'm part of the generation, you and I, and you too, Professor Malvo. Miss, I'm younger than you. we were like, the door was open. And we were like, oh, yes. Right? Our parents are like, you better get in there. You better get while the getting is good. And we did that. And here we are. And now they're like, oh, no, that's enough. Boom. The doors are closing. Because I think I can look at a lot of my colleagues and my friends, and their material circumstances were changed by the educational opportunities that they were afforded, thanks to all those fights over the years, and I'm grateful for that. I am grateful for that, and I cannot stomach that, like, I feel like on our watch, they're shutting it down. Because this is the better way. It just is, right? And it's not just is because I say it is, but the research tells us that diverse bodies make better decisions. It's all out there. It's all out there. Why won't we do that?
Cast.
There it is. It takes. We'll have to talk to. We'll have to bring Isabel Wilkerson here and talk about that. Like, how do we get out of that? But yeah, I am going to read it. It's powerful. The Warmth of Other Suns is one of my favorite books of all time. I think I may have settled down enough that I can recast, I might as well do it before the election, before I get all riled up again. But thank you for that question. And thank you all very much. This has been really fun. It's been great talking to you, and I'll see you at the reception.